Commission. ISDS basically gives additional special rights to foreign investors to sue governments for damages in an international tribunal on the basis of a claim that domestic legislation or policy has harmed their investment. And it's actually developed from a system which originally was about compensating for the actual expropriation of property, real property. But over the years, particularly the last 20 years, it's developed into a system based on principles of indirect expropriation which simply do not exist in most legal systems and which are not available to domestic investors. In this sense, it is not about free trade, it is about giving special preferential treatment to foreign investors compared with domestic investors. The Howard government did not agree to it in the US-Australia Free Trade Agreement in 2004, and that is precisely why the Philip Morris Company, which is a US company, had to go and find another agreement, the Hong Kong Agreement, to sue under. And the Productivity Commission study rejected in 2010, leading to the previous government policy against ISDS. Now, the tribunal system has two fundamental flaws, which means that it lacks the basic legal standards of most domestic legal systems, which ensure independence and consistency of decisions. Firstly, there is no independent judiciary. Arbitrators are selected from investment law experts who, in the main, have represented investor complainants because the system is set up in such a way that only investors can complain under the system. And they can be an advocate 1 month and an arbitrator the next. Now, we regard this as unacceptable as a legal principle. In Australia and in most other legal systems, judges cannot continue to be practising lawyers once they become judges because of the obvious potential conflict of interest. In this system, arbitrators are also paid by the hour because they're not employed as permanent judges, and there is an incentive, therefore, for the cases to take a very long time, and indeed they do take between 3 and 5 years. So it is not an expeditious system, and it does not have an independent judiciary. Secondly, there is no system of precedents or appeals. This means that decisions about cases with similar facts can be inconsistent. Again, in our legal system and in most legal systems, independent judges must take note of previous decisions in an agreed and systematic way, and there are appeal systems which help to ensure consistency. Although many proceedings are held in secret, so we only have incomplete data, the data that we have shows that there's been a steep rise in cases over the last decade, including cases in which foreign investors have sued over health and environmental legislation. And I should say that these are not only old cases, but I'll just give you some examples. In 2012, there was a case brought by a US mining company over the environmental regulation of mining in Canada. There's also a relatively recent case over environmental regulation of mining in Peru. Of course, the tobacco cases against not only Australia but against Uruguay are part of a systematic attempt by tobacco companies to attempt to circumvent regulation of tobacco advertising. The case that I'm sure you've heard about of the Eli Lilly pharmaceutical company is a recent case brought in 2012 against a court decision in Canada over a refusal to grant a patent. And there is also a 2012 case which is of particular interest to those interested in labour rights. The Veolia Waste Disposal and Water Company, an international company based in France, is suing the Egyptian government over a dispute about a government contract which was granted to Veolia, and one of the bases of their complaint about alleging that the Egyptian government has acted in a way contrary to that contract is that after the Egyptian revolution in 2011, the minimum wage in Egypt, which was very low, was raised for the workers employed by Veolia. So they are making a complaint under ISDS against the raising of the minimum wage for workers.